Well, it seems to me that all the previous speakers of this lovely conference have one thing in common. In spite of their differences, professors like Rodríguez, Alexi, and Coleman all have one thing in common. There seems to be one thing that they all wish they could be, which is actually something that the next speaker is: a younger man. The next speaker is Professor Jorge Rodríguez, born in 1964 in Mar del Plata, Argentina. He is professor at Universidad Nacional de Mar del Plata, but he is also a member of the research group in philosophy of law here in Girona. He was awarded a Konex Prize for his research in philosophy of law in 2006. He is the author of the book Lógica de los Sistemas Jurídicos from 2002, and several articles in prominent journals all around the world. It is my pleasure to introduce to you Jorge Rodríguez.
Thank you very much, Christian. And I want to thank Jordi Ferrer, Marcial Pons, and all the people and institutions that have collaborated in the organization of this brilliant Congress. I am very honored to be here because all the rest of the speakers are prominent figures of legal theory, which I'm sincerely not. I will read my paper because of my limitations with the English language, but to stick to the time and not to bore you so much, I will have to jump some paragraphs. In a widely discussed decision in August 2009, Argentina's Supreme Court declared unconstitutional the second paragraph of Article 14 of the Drug Control Act, which sanctions the possession of drugs for personal use as a criminal offense. The arguments of the court center on the scope of the principle of privacy contemplated in Article 19 of the Federal Constitution and several international protocols ranked with constitutional hierarchy. The controversial character of the issue was recognized by the court itself when it acknowledged that its own jurisprudence on the topic had been unstable over the years. In 1978, in Colavini, the court legitimized a criminal penalty for such conduct. In 1986, both Bastarrica and Capalvo rulings reversed Colavini, declaring the paragraph in question unconstitutional. In 1990, in Montalvo, the court returned to the first interpretation, and finally, at least by now, the 2009 new ruling represented a return to the view held in Bastarrica. Among the different interesting questions this set of cases offers for analysis, I want to focus here only on one: the difficulties involved in the truth conditions of legal statements. The statement, in Argentina it is a criminal offense to possess drugs for personal use, seems to have been successively asserted and denied in these different decisions of the court. The problem the court faced in these cases is, with no doubt, very complex, a hard case in which the key difficulty was interpretative in character. In fact, on the one hand, it is a controversial issue whether in hard cases like this one the law is truly determined, and therefore whether there is something that allows assessing the truth or falsehood of statements about what the law requires. On the other hand, the court decided in each of these cases whether a criminal provision sanctioning drugs possession for personal use could be justified on constitutional grounds. Accordingly, the words of the court cannot be taken as theoretical statements about the law. However, let us consider a simpler example. A law professor or just a common citizen making the following statement: in Argentina, murder is a crime. What is the nature of such a statement? Is it susceptible of truth or falsehood? And if the answer is affirmative, what does its truth or falsehood depend upon? I think the most intuitive answers to these questions are that it is possible to make true or false assertions about the law, and that their truth values depend mainly on the content of legal rules. But on a closer look, the justification of these or whatever other answers requires to assume a certain position regarding the most important problems of legal theory. Just to mention some of the most fundamental of them: the identification of the law and the relations between law and morality, the interpretation and validity of legal rules, and the theory of adjudication. In this paper, I will present some preliminary remarks on this problem of the true values of legal statements. More specifically, I will try to defend the following thesis. First, that it is possible to distinguish legal rules from true or false statements about what these rules require. Second, that not all kinds of legal statements are purely descriptive in character and susceptible of truth values. Moreover, some of them share the normative character of von Wright's technical norms or Schauer's instructions. Third, that the possibility of maintaining the distinction between legal rules and true or false statements about law depends on the acceptance of a certain conception of legal rules. Fourth, that the conception of legal rules that allows a defense of such a distinction turns problematic the acceptance of logical relations among legal rules. And finally, that the determination of the truth or falsehood of many legal statements requires, however, taking into account the logical consequences of legal rules. As a starting point for the analysis, it seems of the utmost importance to remember von Wright's distinction between norms and normative propositions. Norms are expressed by means of norm formulations. They are the meaning of sentences used to prescribe, to command, forbid, or permit certain actions, and they are neither true nor false. On the other hand, normative propositions are propositions about the existence of norms, and they are true or false depending on the existence or non-existence of the norm referred to. One of the reasons why these two notions have not always been appropriately discriminated is because the very same words, for instance, parking is not allowed here, may be used, depending on the context, either to formulate a norm or to express a normative proposition. Transposing this distinction to the legal domain, we might say at first sight that legal statements are statements referring to the existence of legal norms, and therefore they express true or false normative propositions about the content of law. Consequently, a statement like in Argentina, murder is a crime, expressed not by a legal authority but by a legal theorist, would not express a norm but a normative proposition relative to the existence in Argentina of a legal rule to the effect that murder is a crime. The relevance of the distinction for legal analysis is, for me at least, apparent and may be shown through the consideration of the problem of legal gaps. In spite of the insistence of hearty and legal positivists on the rejection of the existence of one right answer for any legal problem, Dworkin has claimed that the social sources thesis, a defining tenet of legal positivism, implies the counterintuitive consequence that legal systems are necessarily complete. Dworkin's argument can be formalized, well, in the way you have there in your written version. I have to say that for ignored reasons, there is a missing negation sign in line 3 of this derivation. When it says P is materially equivalent to S not P, it has to say not P is materially equivalent to S not P. I will try to explain this in words. If, from a positivistic point of view, the truth of a legal proposition, like murder is forbidden, is at least materially equivalent to the existence of a social source for such a proposition, this will logically imply that the falsehood of the proposition, murder is forbidden, is materially equivalent to the absence of a social source for such a proposition. But also that the falsehood of the same proposition is materially equivalent to the existence of a social source for the proposition murder is not forbidden. By transitivity, this allows to conclude that the absence of a social source for the proposition murder is forbidden would be materially equivalent to the existence of a social source for the proposition murder is permitted. In a few words, what is not legally prohibited is legally permitted. At first sight, the rejection of this consequence seems to force legal positivists to abandon the principle of bivalence regarding legal propositions. Let me introduce the following slight variation on the reconstruction of the preceding argument. Instead of representing the truth of a legal proposition simply as P, I will use the expression TP, where T stands for the predicate true. And in that case, we would have the following reconstruction you have there. Classical logic not only assumes the principle of excluded middle, that is, that a certain proposition is either true or not true, but also the principle of bivalence, that a certain proposition is true or its negation is true. So, under the assumption of these two principles, the claim that a certain proposition is not true and the claim that its negation is true, that the proposition is false, are equivalent. Of course, if the principle of bivalence is rejected, this equivalence does not hold anymore. From the rejection of the principle of bivalence, it follows that a certain proposition may be true, false, or neither true nor false. And so, not true cannot be taken now as equivalent to false, as the former now comprises not only cases of the falseness of the proposition, but also cases in which the proposition is neither true nor false. Therefore, if we reject the principle of bivalence regarding legal propositions, the analogous of step 4 in the former reconstruction of the argument would be not admissible, and Dworkin's conclusion could be avoided, for the first terms of the biconditionals in 2' and 3' would not be equivalent. This seems to be the path followed by different scholars under the idea that a realist thesis regarding legal statements, implying that every legal statement is true or false according to a certain objective reality whose existence and constitution is independent of our knowledge, is incompatible with the basic thesis of legal positivism. From this perspective, the truth of legal propositions under the positivistic approach could not be conceived independently of the conditions for the recognition of such truth. If the social sources thesis claims that a proposition like in Argentina murder is forbidden is true if there exists a social convention supporting that proposition, then legal positivism would be committed to the rejection of the principle of bivalence regarding the truth conditions of legal propositions. But there is an alternative way of avoiding the undesirable conclusion of the argument that has the advantage of being more deferential to Quine's minimal mutilation maxim. According to this view, the social sources thesis does not hold that the truth of the proposition in Argentina murder is forbidden requires the existence of a social convention for the truth of such proposition. Rather, it says that the truth of the proposition in Argentina murder is forbidden depends upon a social convention for the existence of a rule in Argentina forbidding murder, or better, a social convention for the criteria for identification of a rule forbidding murder as belonging to Argentina legal system. Thus, what is needed to avoid the conclusion Dworkin attributes to legal positivism is not the rejection of the principle of bivalence, but to distinguish clearly between legal rules and propositions about them, something that is impossible in the previous reconstructions of the argument because the symbol P was being ambiguously used to represent both norms and normative propositions. By taking seriously the distinction and replacing P as means to represent a legal proposition, like in Argentina murder is forbidden, for something like the rule murder is forbidden belongs to the legal system LS, it is possible to reconstruct the premises of the argument as you have there. According to this reading of the social sources thesis, the proposition that in legal system LS murder is forbidden is equivalent to the existence of a social source in LS for the rule murder is forbidden. The claim that in legal system LS there is not a rule forbidden murder is equivalent to the absence of a social source in LS for the rule murder is forbidden. And to say that in legal system LS there is a rule not forbidden or permitting murder is equivalent to asserting the existence of a social source in LS for the rule murder is not forbidden. When we distinguish norms from normative propositions, it is possible to notice there are two different senses in which an action may be said to be permitted. A mere negative sense, there is no forbidden norm, and a positive sense, there is a permissive norm. The absence of a social convention for the identification of the norm murder is forbidden as belonging to legal system LS is not equivalent to the existence of a social convention for the identification of the norm murder is not forbidden as belonging to LS. Hence, legal positivism is able to avoid a counterintuitive consequence that its basic thesis implies the necessary completeness of legal systems without any commitment to the anti-realist thesis that rejects the principle of bivalence regarding the truth conditions of legal propositions. In spite of all the light this distinction between norms and normative proposition is capable to shed on the analysis of legal system, there are certain shortcomings in this simplified approach. The first problem can be presented using an idea set forth by Tecla Mazarese, who argues that norm propositions lack truth values. Her skeptical view rests on the following thesis. First, a norm proposition is not the meaning of a single statement, but of a disguised conjunction of at least two statements, an interpretative statement and a validity statement. Second, neither interpretative statements nor validity statements can be conceived of as descriptive statements. And finally, neither interpretative statements nor validity statements can be conceived of as true or false statements. In Mazares's view, on the one hand, validity statements involve an evaluation of the act of promulgation of a certain norm formulation, so they cannot be purely descriptive assertions. On the other hand, interpretative statements assign a certain meaning to norm formulations. But Mazarese also claims that there is not a unique interpretation that can be considered correct or true of any norm formulation. Therefore, the process of identifying the norm expressed by it would never render a unique result, and thus interpretative statements cannot be purely descriptive either. I believe that Mazarese's argument do not allow deriving such a strong conclusion as the one she has in mind, that all norm propositions lack truth values. Notwithstanding, her ideas stress an important aspect of an intuition held by many legal philosophers. When we restrict to the legal domain, legal science has a normative dimension that seems to exceed the fact that it deals with norms. The tasks of legal science are complex, and with no doubt, not all and not even the majority of its statements can be assimilated to normative propositions in the sense explained above. Therefore, it's undeniably true that most statements of legal science are not susceptible of truth or falsehood. And this is so because two of the most important tasks of legal science are the ascription of certain interpretation to problematic norm formulations and the evaluation of compatibility of certain norms with higher ranked norms, and both activities have an evaluative content, as Mazarese remarks. It's impossible to examine here in detail the many different approaches that have been defended in legal philosophy concerning the nature of legal statements. Moreover, they are widely and sufficiently known. What I would like to stress is that the two aspects of the problem indicated above, the different conceptions of legal interpretation and on legal validity, allow introducing certain classificatory order over these approaches. Oversimplifying things, of course, on one extreme of the scale, we might place those scholars that hold, on the one hand, that interpretation of legal rules is a non-cognitive activity that always involves an authoritative decision, and on the other hand, that legal statements are purely descriptive in character. Art Ross and other defenders of legal realism would be representative of this perspective. On the opposite extreme of the scale, we might place those scholars that hold a cognitivist conception of legal interpretation, according to which there is always a right answer to any legal case, but at the same time they claim that statements on the validity of legal rules have the same character as the object to which they refer. They are normative and not descriptive. Dworkin and many natural law theorists may be taken as representing this point of view. A great number of intermediate positions are conceivable in the ample space lying between these two extremes. Because of its significance, I would like to make some brief remarks on Kelsen's account of the problem. Kelsen has always defended the separation of is and ought. This idea has been influenced by two different philosophical trends that lead to a strong and a weak version of it. First, in his earlier works, he presents the idea of a world of ought as a category of understanding different from and not reducible to the world of is, that stems from the Kantian tradition. In this ontological version of the distinction, there are two realms or worlds entirely different, the world of is and the world of ought, each of them ruled by a logic of its own. In his later works, Kelsen offers a weaker version of the same idea. The distinction appears now in terms of two different uses of language, prescriptions and descriptions, each of them with a logic of its own, with the consequence that from a set of purely descriptive statements, a set of prescriptive statements cannot be inferred and vice versa. Thus, Kelsen subscribes to the idea that there is no logical bridge between is and ought, and therefore condemns the naturalistic fallacy. However, still in this second version of the distinction, there are residues of a much stronger one that transcends a mere difference in uses of language. These residues are reflected in Kelsen's approach to the so-called legal statements describing legal norms, an issue closely connected with the Kelsenian conception of legal science. The difference between legal statements and legal norms was not at all clear in the earlier works of Kelsen, where he seems to confuse both ideas. However, at least since the general theory of law and state, he seems to distinguish between true or false legal statements, rules of law he calls them, and legal norms that lack truth values. However, Kelsen states that though legal statements are true or false, they are ought statements, not only because they refer to legal norms, but also because they identify a norm as valid. And in the Kelsenian framework, validity is a normative concept. To say that a certain norm is valid is tantamount to saying that one ought to do what that norm prescribes. That is the reason why Kelsen thinks that legal statements not only have certain empirical facts, but also have normative dimension. They are ought statements. The Kelsenian idea that legal statements are ought statements that do not express prescriptive but descriptive duties seems nothing but product of a confusion deriving from the ambiguity that systematically affects the ontic terms, which are liable to be read both descriptively and prescriptively. Alf Ross and Herbert Hart, among others, have criticized this idea in extent. According to Ross, legal statements cannot be ought statements if they have truth values. Kelsen's use of the concept of validity as binding force, similar to the one we find in natural law theorists, entail that the propositions of legal science have a normative character not compatible with a positivistic theory of law, for they refer to the validity of legal norms. Hart has objected the Kelsenian idea of descriptive duties with the aid of the distinction between use and mention of words. He says that when the lawgiver enacts a law, she uses certain words, while when the jurist tells us what the law means, she mentions the very same words. And thus the word ought would be mentioned but not used in the statements of legal science. However, Kelsen's explicit rejection of this reading pushed Hart into reconsidering the point. He proposed an analogy with the relationship between a speaker of a foreign language and his interpreter. Suppose a foreign commander in a prisoner camp issues an order translated by the interpreter as "stand up." The interpreter's statement is neither an order, because she is not an authority, nor a second-order statement that mentions the original words and correlates them with a certain meaning. The interpreter's statement tries to reproduce the order. It is a special use of language, and we could say with Kelsen that here the use of the grammatical imperative was descriptive and not prescriptive. Nevertheless, Hart points out that logic has received substantial development in the last centuries to be satisfied with this problematic category of descriptive oughts. Hart's distinction between statements formulated from an internal point of view and from an external point of view, as well as Ra's category of detached legal statements, may be seen as an attempt to elucidate the problematic character Kelsen assigns to legal statements. I will only refer to the idea of Ras. According to Ras, legal scholars can use normative language to describe the law and make legal statements without endorsing law's moral authority. This kind of statements makes use of normative terms, and the speaker formulates them from the point of view of those who accept the rules, But this point of view is not necessarily shared by her. The speaker does not necessarily assume any commitment with what the rule requires. Those statements can be exemplified by advices given by an expert on a certain system of rules who does not endorse such rules to someone that accepts them and has doubts on what they require regarding certain situations. As Bajon has pointed out, the possibility of formulating detached legal statements or statements formulated from a point of view allows accounting for the way in which normative language can be used to describe a legal system without assuming any axiological commitment to it. Discussing this kind of statements, Raz claims that they are normative, though he also states that they can be true or false. Similarly, Hart maintains that they are normative statements but can be used to describe the law. Being that so, it seems that we have not gone far beyond Kelson's descriptive odds. So it could be argued that the normativity of detached statements or statements from a legal point of view is no more than the result of using in them deontic expressions like ought, duty, or obligation. However, as we have already seen, deontic expressions can be used to express either genuine norms or normative propositions. Thus, if detached legal statements are deemed true or false, they will express normative propositions. I believe, however, there is a way to conceive of the character of detached legal statements that gives a more faithful account to the plight that they are meant to grasp, and it consists in assimilating them to what Fonright calls directives or technical norms and Schauer calls instructions. Detached legal statements, like directives, have a standard conditional formulation in whose antecedent there is mention of some wanted thing and in whose consequent there is mention of something that must or must not be done. An example would be, if you want to comply with this system of rules, then you should. Here the antecedent mentions the end to be attained, the fulfillment of the obligations derivable from the system of rules, the attainment of which depends upon the agent's will. And the consequent mentions the action that must or must not be done to comply with the system. Directives or technical norms are neither true nor false, but there is a logical connection between them and certain descriptive statements to the effect that the action recommended is a necessary condition for the attainment of the end, expressing what Fonright calls anancastic propositions. In similar terms, Schauer claims that instructions are optional in two ways. First, because they are applicable only if the agent wishes to succeed in the pertinent task, in our case, to obey a system of rules. They are hypothetical, containing an explicit or implicit if clause limiting its application. Second, they are optional because their force to motivate our conduct depends on our assessment of the likelihood that they will produce the desired result. If, on the contrary, we believe that at least in this case the instruction will not lead to that result, the rule's force evaporates and we will feel free to ignore it. According to Schauer, the reason is that instructions work as rules of thumb, providing useful guides for ordinary cases, but not taken even by those who accept them as exerting any normative pressure qua rules if we believe that, in spite of following the guide they offer, the desired goal will not be attained. This is tantamount to Fonright's idea that the efficacy of directives depends upon the truth of the anancastic propositions presupposed by them. Were they false, the efficacy of the directive would disappear, or what is the same, their force to motivate our conduct evaporate. Under this interpretation, detached legal statements are not by themselves true or false. What would be true or false is the information presupposed by them regarding the rules of the legal system, and they are normative statements in the peculiar sense of normativity attributable to rules of thumb. Whether the information they presuppose concerning legal rules is correct, they are apt to bring about a practical difference for the addressee. Nevertheless, they actually do not provide genuine reasons for action, but rather reasons to believe on the existence of reasons for action. Many statements formulated by legal scholars can be interpreted in this way. As I said before, the tasks of legal science are complex, and many of its statements are not susceptible of truth or falsehood. Nevertheless, if we reject a radically skeptical conception of interpretation, one according to which the law is absolutely indeterminate, and accept that there is at least one sense of validity according to which qualifying a norm as valid merely indicates that it belongs to a certain normative system, then we should admit the possibility of asserting at least some true normative propositions about the content of law. A second problem with the distinction between norms and normative propositions is that its viability depends on the conception of norms we adopt. At least at first sight, we might say that there are three different ways to characterize norms according to their relation with language. A syntactic conception, where norms are identified with linguistic entities, sentences in which certain normative expressions, such as obligatory, permitted, etc., are used. Second, a semantic conception, where norms are conceived of as the meaning of certain linguistic expressions. In this sense, norms are proposition-like entities. They are the meaning of prescriptive sentences, just like propositions are the meaning of descriptive sentences. And third, a pragmatic conception, where norms are the outcome of the prescriptive use of language. The same proposition may be the object of different linguistic acts. It may be asserted, conjectured, questioned, ordered, and each of these different acts would produce different results: an assertion, a conjecture, a question, an order. From this point of view, the possibility of distinguishing norms from other entities is neither at the syntactic level nor at the semantic level. It would require taking into account the different uses of language. Of these three alternatives, there is a powerful argument to reject the first, the syntactic conception. Norms cannot be identified at a mere syntactic level because, as has already been said, the very same linguistic expression can be used to express either a norm or a normative proposition. We are then left with the semantic and the pragmatic conceptions. Alchuron and Buligin have respectively called these two alternatives the highlightic and the expressive conception of norms. And they have shown that the option we favor between these two different ways of characterizing norms has important consequences on the kind of relations we may accept among norms, particularly on the question of the admissibility of logical relations among them. The possibility of accepting in logic of norms requires to offer an answer to a primary difficulty which forces us to reconcile certain pre-analytic intuitions that seem to be in conflict. On the one hand, it seems natural to think that norms lack truth values. But on the other hand, logic has been traditionally associated with the notions of truth and falsehood, in the sense that the concept of logical consequence, as that of contradiction, and the meaning of logical connectives have been defined in terms of truth. Consequently, it seems that the scope of logic is limited to descriptive statements. Yet, it is common to derive certain norms from others, and a clear example of this seems to be the common obligation to offer justification of legal decisions. Moreover, there seems to be no substantial difference in the use of the logical connectives from descriptive to prescriptive discourse. Jorgensen presented this problem in the form of a dilemma, and it may be said that the different answers offered to it mark the historical evolution of deontic logic. The dilemma is this: under the assumption that norms are neither true nor false, there are only two possible alternatives concerning the applicability of logic to normative discourse. Either the notion of logical consequence and the logical connectives are defined in terms of truth, in which case there is no possibility for a logic of norms, or a logic of norms is possible, but then the scope of logic has to be wider than descriptive discourse. And the notion of logical consequence, as well as the logical connectives, should not be defined in terms of truth, what contradicts a firmly established tradition. Alchuron and Buligin argue that among the supporters of the semantic conception, there are those who defend that norms have truth values and therefore accept a logic of norms, but also those who reject the former idea. In this second view, it would still be possible to justify a logic of norms, but to support this possibility would be necessary to assume that logic exceeds the realm of truth. And for any of these two different perspectives, it would be possible to distinguish a genuine logic of norms from a logic of normative propositions. By contrast, they consider that the supporters of the pragmatic conception can only accept a logic of normative propositions because within this view, norms are facts, and between facts there are no logical relations. I partially disagree with these ideas, but to explain my differences, a closer examination of these two different conceptions of norms is needed. Using a well-known idea introduced by Elizabeth Anscombe, it may be said that when language is used to describe, it has a language-to-word direction of fit. What is tantamount to saying that in case of a discrepancy, the problem is not in the latter but in the former. By contrast, when language is used prescriptively, the direction of fit goes in the opposite direction. So, when the subject of this prescription does not act as required, the problem is not in language, but in the word. This is the explanation of norms and their differences with other entities which characterizes the pragmatic conception of norms. From this perspective, the difference between the assertion that P is the case and the prescription that P ought to be the case rests on the different propositional attitude adopted by the speaker. Norms are instances of a prescriptive use of language where the direction of fit is from word to language. The supporters of the semantic conception of norms need to offer an alternative reconstruction of the difference between propositions and norms. The most promising way of doing this seems to rely on a possible word semantics. One can say that while what determines the truth value of the assertion that a certain proposition P is the case is something that occurs in the actual world, what determines the truth value of the assertion that P is obligatory is something that occurs not in the actual world, but in those possible worlds which are normatively ideal with respect to the actual world. Hence, a norm like obligatory P would be true in the actual world if P were true in every possible world which is normatively ideal regarding the actual world. Of course, presenting the difference between descriptive statements and norm in this way involves accepting that norms are capable of truth values. It's important to notice that possible world semantics need not necessarily assume the controversial claim that norms are proposition-like entities. For instance, one can say that prescribing that P is obligatory in the actual world is tantamount to preferring as normatively ideal with respect to the actual world those possible worlds in which P is true. But if we opt for this alternative explanation, the difference between the assertion that P is the case and the prescription that P ought to be the case would be pragmatic and not semantic. In other words, only one of the following two alternatives is possible. We may understand that the direction of fit of the sentence expressing a norm like obligatory P is from language to the world, in which case the sentence will try to register what happens in certain normatively ideal worlds and will be true or false depending on its success in doing so. The alternative option is that the direction of fit of such sentence is from word to language. In that case, the sentence itself will determine which words the speaker deems normatively ideal, and norms will lack truth values. Accordingly, either we adopt the semantic conception of norms and simultaneously accept that they are capable of truth values, or we follow the pragmatic conception. There seems to be no conceptual room for assuming the semantic conception and reject the attribution of truth values to norms. On the other hand, from the pragmatic standpoint, it seems at first sight that a genuine logic of norms is unacceptable. Logical relations would only be admissible among normative propositions, among descriptive statements about the existence of norms. Now, the challenge for this point of view consists in offering a system of logic for normative propositions, not presupposing logical relations among norms themselves. However, as von Wright has demonstrated in one of his last papers, such system will be nothing but a simple application of propositional logic in the sense that there will not be any specific laws for normative propositions. Therefore, On this view, either we accept that the realm of logic is wider than truth, and consequently we accept the existence of logical relations among norms, or we have to reject even the possibility of a logic for normative propositions, unless we are ready to give such a dubious title to a mere instance of propositional logic. The ultimate reason that justifies these conclusions is that I suspect that behind the distinction between the semantic and the pragmatic conceptions of norms, there are in fact two different views on meaning. One according to which meaning is explained exclusively in terms of truth conditions, and the other in which the pragmatic aspects of language participate in meaning. From the first point of view, norms will have a direction of fit from language to word and will be capable of truth values, and from the other, norms will have a direction of fit from word to language and lack truth values. Under the first approach, Jorgensen's dilemma is avoided, and it's easy to justify the possibility of logical relations among norms, but only because within this perspective, norms are conceived of as proposition-like entities, and therefore are capable of truth and falsehood. Now, an important corollary of this point of view is that precisely because of this characteristic, the distinction between norms and normative propositions cannot be maintained, because norms themselves are propositions about what ought to be the case. The only distinction we may draw here is between the assertion that P is obligatory according to the norms of a certain normative system and the assertion that P is obligatory simpliciter, that is, between relative normative propositions, relative to what ought to be the case according to a certain set of norms, and absolute normative propositions, all things considered. By contrast, under the second approach, the idea of norms having truth values is unacceptable. From this perspective, it is certainly possible to maintain the distinction between norms and normative propositions, but either we reject the existence of logical relations among norms, or we have to face Jorgensen's dilemma through its second horn, and contrary to the traditional view, justify that the scope of logic is not limited to truth. Let's now return to the analysis of legal statements. If the ideas presented above are sound, then it is possible to show a different kind of difficulty in the projection of the distinction between norms and normative propositions to the legal domain. To illustrate the point, let me go back one more time to Kelsen and his view on legal statements. In his most representative writings, Kelsen has defended an Kelsen has defended a non-cognitivist conception of norms, according to which they lack truth values. In the second edition of the Pure Theory of Law, he affirms that logic cannot be applied directly to norms. However, logical principles and the notion of contradiction are, in his view, indirectly applicable to legal norms through their application to the legal statements that describe them. In later works, Kelsen goes further and rules out the possibility of an indirect application of logic to norms. But in spite of these variations, it is clear that Kelsen definitely opts for the first horn of Jorgensen's dilemma. Norms are not capable of truth values, and so there are no logical relations among them. Yet, the problem with this idea is that the analysis of what the law requires, at least in certain cases, makes it necessary to take into consideration not only the content of those norms that have been explicitly enacted by certain authorities, but some of their logical consequences as well. The expression legal system is used many times to refer to the reconstruction of the set of norms that are relevant for solving a certain case. This reconstruction seeks to determine the consequences that follow from a certain set of norms regarding a certain theoretical or practical legal problem. It tries to identify the kind of operation that legal scholars perform when they examine the solutions deriving from the law in force regarding a real or hypothetical case. Here, the logical consequence relation is what determines the systematic structure of the set. To illustrate this, I would use once more a recent decision made by Argentina's Supreme Court. In 2004, in the Aquino ruling, the court declared unconstitutional Article 39(1) of the Labor Risk Act, which excluded in labor accidents the possibility of claiming from the employer full compensation even in cases of severe negligence, because the employee's system of fixed and limited compensations through assurance companies, established in Article 15.2 of the same Act, produced in the case at hand a result that was insufficient to cover the damages suffered by Mr. Aquino in violation of constitutionally entrenched rights. The arguments used by the court seem to indicate that Article 39.1 of the Act by itself was not taken to be incompatible with the Constitution in abstract terms, because if the assurance system of compensation were wider and not restricted to the limited items it took into account, it would be reasonable to substitute the employer's responsibility for a more simple and efficient system. And the same goes for Article 15.2 of the Act, because if the victim of a labor accident were allowed to demand from her employer full compensation in cases of serious deviation, as it happened in Aquino, the fixed compensation assurance system would not by itself conflict with the Constitution. These ideas held by the court generated an extended controversy among legal scholars in Argentina, which have been discussing up to present days on the exact scope of the decision. In my view, what follows from the court's remarks is that neither Article 39.1 nor Article 15.2 of the Act, when considered in isolation, was in conflict with constitutionally entrenched rights. The problem was generated by a consequence of the conjunction of both norms, and the controversy produced by this ruling is nothing but the result of the indeterminacy generated by the incompatibility with higher ranked norms of a consequence of a set of other norms, each of them compatible with those superior in hierarchy. The analysis of complex cases like this makes it necessary to take into account not only explicitly enacted norms, but also the consequences that can be derived from them. To sum up, I have tried to show that the distinction between legal norms that lack truth values and true or false statements about the content of the law requires committing oneself to a conception of norms within which justifying the existence of logical relations among norms proves very difficult. Nevertheless, statements of legal scholars are in many cases not relative to what enacted legal norms provide, but to their logical consequences. Indeed, the derivation of all the consequences that follow from enacted legal norms seems to be another important task of legal science. Still, in order to give due account to this intuition, an answer should be given to the problem of the foundation of a logic of norms when they are conceived of as lacking truth values. But this problem is, of course, far beyond the limits of my paper. Thank you very much.
Okay, thank you very much for this excellent paper. We have a little more than half an hour to debate before the lunch break at 1, and maybe we will start with Scott.
Thank you. I thought that was really interesting. So I wanted just to kind of ask you about your interpretation of detached legal statements as technical norms. So one reason for skepticism that is a adequate interpretation of detached legal statements is that it kind of ignores the categoricity of law. So the categoricity, the idea that the normativity of law, if it does give you reasons, gives you reasons irrespective of what you want, right? So it doesn't kind of really matter whether you want or not want to commit murder. You're just not supposed to. I mean, that's what the law is telling you. So, so for example, let's say to be concrete, the judge says to the convicted murderer, you know, you're now under a legal duty to report to prison for 20 years. Now, if that, and let's say that's a detached legal statement. It's not committed. It's detached. Now, on your interpretation, if I understood you correctly, it's if you want to conform to the law, then you must report to prison. But of course, the judge knows he doesn't want to report, conform to the law. I mean, that's how he got there. And so it would be an irrational thing to say to the convicted murderer, if you want to conform to the law, you're going to present. The whole point of it is to say, I don't care, you know, it doesn't matter whether you want to or not, you're under a duty to. So that's why maybe there's a piece of the puzzle I'm missing or misinterpreting you. It just seems to me, it's true that the technical, that a statement which formulates the technical norm is implied by the detached legal statement, but I doubt it's equivalent. Anyway, that's the worry.
I would say my intention was trying to give an explanation of why this ambiguity, well, what seems to me an ambiguity in RAS analysis, that detached statements are normative but are either true or false. My idea is that, or there's something I miss here, but the idea of technical rules, of technical norms or directives in the sense of von right or instructions in the sense of shower, is able to take into account this connection with truth values, but to preserve in some way the normative character of detached legal statements. In this interpretation, detached legal statements are normative, but their normativity is a special kind of normativity, one that we could compare with rules of thumb, because the normative force of the statement is based on certain assumptions, certain presuppositions, certain information about the rules of the system, and that's the force of and in that information depends the normative force of the statement. I don't know if this is a very good reconstruction, but I think to compare detached legal statements with instructions or normative directives was for me illuminating, in the sense that, well, it allowed me to understand this strange connection between true and false, and truth and falsehood, and normative power. I'm sure there are better analyses of this problematic character of detached legal statement. Professor Dahlman here has written a certain paper on the subject, and I've read other articles on the subject. But I thought it was interesting to make this comparison with directives or technical norms for this reason. It allowed me to understand how could certain information about the content of a legal system could be relevant to give normative force to the statement. I don't know if I could answer to your question.
Okay, I think I saw Jose Juan raising his hand. Is that right? Yep. Could you please pass the mic?
Jose, I raised it before you.
Okay.
Okay.
Okay, since you have the mic, okay, please, and then Jose Juan afterwards.
Thank you. Well, I have a great and wide agreement of the ideas of Jorge, but I would like to put two questions. First question is, what kind of disagreement we have when we disagree, for instance, of your example, the sentence in Argentina, it's a criminal offense to possess drugs for personal use, or according to the American Constitution, the capital punishment is excluded as cruel, or according to Spanish constitution, the same-sex marriage is valid. What kind of disagreement are these disagreements? For less disagreement, this proposition have truth values or not? Are genuine disagreements or not? And I think that it's a very important question about normative propositions, about this kind of normative legal propositions. And the second question is whether or not affect the decision of the courts this kind of propositions. If the Supreme Court of Argentina said, as in fact it said, that this proposition is true or is false, but decide in this sense, this affect the truth values of the proposition or not? And if not, what's the role of the court in this situation? Thank you.
What kind of disagreement? Well, I think there could be a theoretical disagreement about the content of our normative practices. I mean, we could restrict our interpretation of the social sources thesis to an understanding according to which we need agreement on the cases of application of a legal rule. But that seems to me that gives that's a position that has no possible answer to questions like yours. I mean, how we explain our disagreements on the content of I think there are other possibilities of interpreting the social sources thesis. We may interpret that the social sources thesis restricts to saying something like there are social facts that determine the sources of law, and nothing more than that. The legal norms have to be identified from such sources, and the interpreter is free to do that. I mean, we could understand the social sources thesis as having no implication on the identification, or at least directly on the identification of legal rules. But I think both of these understanding of the social sources thesis are unacceptable. I think that the social sources thesis, what says is something like we need an agreement to identify a certain set of rules, but that does not necessarily imply that we need a complete agreement on the way we have to apply those rules. There may be criteria or standards of correct applications of such rules that are implicit in our normative practices, and we may have disagreements. We may disagree about what the rule requires in a certain case. So the kind of disagreement that you presented as an example may be analyzed in these terms. I think legal positivism is not compelled to a reading of the social sources thesis that has no answer to the problem of our disagreements about the application of, and this case is the case of the unconstitutionality of a criminal offense, sanctioning as a criminal offense the possession of drugs for personal use is a case where we have to determine the exact scope of norms of the Constitution. And well, I think that a situation like that could be analyzed in terms of a theoretical disagreement about what is implicit in our understanding of the scope of these rules. And concerning your second question, the decision of the court in a problematic case like this affects the content of the law. I think that the answer is it may be. It depends on what the rule of recognition says. It may be the case that in a certain legal system, decisions like this, I mean, the rule of recognition can give different effects to decisions like this. In Argentina, a decision of the Supreme Court does not force the judges and lower hierarchies to follow necessarily the criteria set by the court. So I think this is not the case in other legal systems, and so I think it depends on the configuration of the rule of recognition. It's a contingent matter if it affects or it does not affect the content of the law.
Okay, then the eager gentleman at the back, please.
I agree completely with the proposal. In fact, I have a paper with the same proposal of interpreting the propositions of legal science as anarchistic statements or as technical rules. And actually, in the way, unfortunately, it's in Portuguese, but the proposal is I apply Searle and van der Vecken logics of illocutionary acts, and then using the example by heart, where you have stand sie auf, and then the translator says stand up. The suggestion is that the description by the translator has 2 points. First, it describes the illocutionary act or the illocutionary force by saying it's an order. And then it describes the content of the order. And the content is that you have to, that is standing up. If you see these two, this illocutionary force which is described, this makes the illocutionary force of the description to be not a description at all, but to become a technical rule. By saying that it is an order and what's the content, what has to be done, what's the content of the order, he says what has to be done in order to comply with the order. And responding to Scott, actually, you don't have to in this discourse, you don't expect the subject to want or not to follow the order. Actually, in this discourse, it is presupposed that the subject is going to comply. It's a discourse by legal science directed to those who want to comply. I'm not talking to those who don't want to comply. So it's something like that. So it is presupposed, and logical concepts apply to the discourse because it's a discourse which will want to guide behavior. So if you are guiding behavior by this discourse, you cannot give conflicting recommendations. So logic applies to that. So the problem that I see with this proposal now is not that suggested by Scott, but it comes from, I ask permission to tell a small joke. The problem comes from this example. So General MacArthur is in Japan, and he is making a conference to Japanese, and he tells a long joke. And after he finishes, the translator says 2 words in Japanese, and everybody laughs. Then he becomes intrigued and asks the translator, how did you translate my joke in so few words? Then he says, I said it was a joke, please laugh. So what does this joke say? It says that maybe it was a successful and sarcastic statement by the translator. He said, it's a joke, do this, and this will mean complying with what he wants. But we wouldn't say it is transporting this to legal science. If you have something like that, where you say, do this, but it's not exactly what is commanded, that is, the subjects are going to follow, but not follow at all what is the command. Then this is a problem about this proposal, and I don't have the how to solve it right now. But I remember that in Hart's paper, where he discusses this Kelsen visited paper, he first uses the idea of use and mention, the hypothesis of mentioning and Kelsen doesn't like it. But then in the end of the paper he says, maybe I was wrong, and maybe the better approach would be to say that the translator represents somehow the order, and legal science is a sort of representation of the order of the authorities. And maybe there is some truth there. Of course, the notion is not clear, he doesn't explore it, but what I'm worried about this approach is this. There may be sarcastic statements which has the perlocutionary effect, is successful as a means of discourse, but it's not really, we wouldn't say, a true description of both that it is an order and both what is the content of the order. So that's an interesting problem as I see.
I really have no answer to those problems now. I thank you very much for your help in replying, Shapiro. I'm sure this suggestion of comparing detached legal statements with directives or technical norms is insufficient as an analysis. I just wanted to stress this idea that in some circumstances information can make practical difference. But apart from that, I'm sure this needs a refinement.
Okay, Pierluigi?
Some genuine question about what you say at page 20. Nevertheless, if we reject a radically skeptical conceptual interpretation, then we should admit the possibility of asserting at least some true normative proposition about the content of the law. Here, really, I suspect, but it's a question, but here maybe you are using a faulty theory of interpretation, because if
you are using, sorry.
But here you are using a faulty theory of interpretation, the Bulygin theory, we may say, in a sense that when a jurist does interpret something, even though the meaning is the literal meaning, he makes an act of a decision, so he takes sides. He uses an interpretation, doesn't mention it. Otherwise, it can only be something like recording past interpretation, predicting future interpretation, conjecturing. Okay, that's it. What's your theory of interpretation behind these statements you make?
What?
Thanks.
Sorry?
Sorry. What's your theory of interpretation behind this statement you make at page 20?
I just mean that I think a radical skeptical view on interpretation renders the law absolutely indeterminate. The law would be no more than a set of norm formulations, but open to interpretation, to the free decision of interpreters. The only thing I'm suggesting here, I have tried not to take sides on the problem of interpretation in this paper, because I try to simplify the analysis to situations of simple cases. I avoided the problems like the one I presented. I used the example of the Supreme Court of Argentina in the first page precisely because I wanted to exclude those situations for it compels to take sides in the theory of interpretation. The only thing I have said there was that if you reject an extreme skeptical view according to which law would be absolutely undeterminate, then we can have some true or false statements about the law. Otherwise, the only true or false statements you can formulate are after there has been an interpretation, after a decision has been taken. Or prior to this, you have nothing but texts without interpretation, so you can say nothing about the content of the law. My statement was not more pretentious than that. That in any theory of interpretation that excludes this radical skeptical view, we can accept that there is some kind of objectivity in the law, and so there can be some true or false statements about the content of the law. But I insist, I have excluded in the consideration of my paper the problems related to interpretation, and I have excluded many other important things because it is impossible to analyze exhaustively all the circumstances that have an impact on the problem of the determination of the true of the truth values of legal statements. Other problem that I have said absolutely nothing in this paper is about the concept of validity, and that's of utmost importance to determine what we understand for the validity of a norm, to be able to say something about the truth values of legal statements. I try to concentrate my attention on certain very restricted theses. The importance and the way we can project this distinction between norms and normative propositions to the legal domain, and the difficulties involved in this. To say more about legal statements, we have to give an answer to problematic questions like what theory of interpretation we can sustain, what theory of validity we can sustain. Without an answer to these problems, no answer is complete about the truth values of legal statements.
Okay, Giovanni, please.
A very short question. You assume in your paper that technical norms are neither true nor false, but it can be questioned if one considers the differences between technical norms and other kinds of norms. So, what is, in your opinion, a good argument to claim that technical norms are neither true nor false?
What? Sorry?
What is, in your opinion, a good argument? Because you seem to assume this without giving an argument. Yeah.
The idea of a technical norm is that it presupposes a true or false statement, but is not by itself true or false. So a technical norm does not indicate that a certain thing is a necessary condition for another, but if you want this, then this is the means you have to use to obtain it. So, in at least as I understand the idea von Wright, technical norms are not by themselves true or false. They presuppose a certain statement that has to be true for the efficacy of the directive, but by itself it is neither true nor false.
Okay, then a question from the front.
Thank you. Well, this is a nice paper. I only have two minor objections. You say that in a semantic conception in which it is admitted that norms have truth values, the direction of fit is from the language to the word. And you also say that in this conception it is impossible to distinguish between norms and normative propositions because norms themselves are propositions about what ought to be the case. Well, it seems to me that in the first place that the direction of fit in this view is not from language to the word, but from the language to ideal possible words, which are different from the actual word.
In that you are correct.
In the second place, it seems to me that it is possible to distinguish between norms and norm propositions because norm propositions are not propositions about what ought to be the case, but propositions about what norms say that ought to be the case. But if it is possible that there are true norms, it must also be possible that there are false norms. And so it is possible that a normative propositions say that a norm says that something ought to be the case, but it is false that ought to be the case because the norm is false.
Yes, I thought something like what you have said. Maybe it's too strong to say in a few words, like I try to say here, that within this conception of norms, it is impossible to distinguish between norms and normative propositions. What seems clear to me is that the distinction loses part of its sense because the importance of the distinction lies in the fact that a normative proposition is relative to the existence of a norm, describes the content of a norm, and norms are not true or false statements. But I think that if you assume the conception, this semantic or whatever you want to call it, conception of norms, according to which norms are proposition-like entities, you can distinguish metalinguistic expression relative to what a norm says, like what you have said. But the problem is that normative propositions are usually expressed in the same terms that are expressed norms. The normative proposition does not say, at least in their usual form, norm N says such and such thing. The same words are usually used to express norms or normative propositions. So I think that when you assume that norms are proposition-like entities, at least the importance of the distinction loses its meaning. You may distinguish metalinguistic references to what norm says, but that was not the importance of the distinction between norms and normative proposition, between two radically different entities. I recognize that, I acknowledge that maybe my statement here is too strong, but I believe that, as it says in the paper, when you really think that norms are proposition-like entities, norms themselves are propositions about what have to be done, what ought to be the case. And so to distinguish norms and normative propositions is less clear than in the alternative conception. It's just an aim to call them norms, because all are propositions about what ought to be the case. So, as I say here, what you can distinguish is, or to preserve the idea of norms and normative propositions in the alternative conception, the only thing you can say from this perspective is that you may assert a relative proposition or an absolute proposition. Norms would be in the correlate of this absolute propositions, and the correlate of normative propositions, which are relative to what certain norm says, would be propositions, normative propositions relative to the content of certain normal sets of norms. But there is no categorical difference, I mean, between norms and normative propositions within everything are propositions, because norms themselves are propositions. I insist, maybe it is too extreme to say that you cannot trace the distinction, but at least it doesn't have the same scope that on the alternative conception.
Okay, we have time for 2 short questions, and the first one comes from down here.
Thanks. It seems to me, Jorge, that there is a mistake, even a clear mistake, I dare say, in page 1 of your paper. Let me quote. The statement, "In Argentina it is a criminal offense to possess drugs for personal use," seems to have been successively asserted and denied in these different decisions of the High Court. Are you sure that the High Court just makes statements about the law? Well, maybe this mistake is unimportant, just an unhappy formulation, but maybe not. And this is the reason why I just call attention over it. Maybe it supposes, say, a bad conception of normative propositions. Namely, the Kelsenian concept of normative propositions, conceived of as statement, propositions, sentences describing obligations, rights and obligations, and so on. But why not conceive them more simply as proposition describing the law in force? That is, attitudes, beliefs, and behaviors of officials, or something like that. What I mean is that if this statement, "In Argentina it is a criminal offense or not," is referred to a legal scholar, I really cannot see any serious problem as to its truth value. It is a true statement today. It was false today. After the last decision of the court, it was false in 1978 and was still false until 86 and so on. What is the problem?
First, I use this phrase you have quoted to present the discussion, but it's corrected in the following paragraph, where I try to clarify that the statements of the court cannot be taken as theoretical statements about the content of the law. So I accept this is not a very clear way to present things, but I use the example because it seemed to me that the interesting question, which I have not addressed in this paper, about the truth values of legal statement concerns precisely two cases, problematic cases like this. Concerning your idea that with respect to problematic cases like this, it is possible to make true or false assertions about the law. That would be true now, after this decision of the court, that the possession of drugs for personal use in Argentina is not a criminal offense. I have my doubts because, well, at least I insist, the effect of of judicial decisions concerning the content of the law is contingent upon the rule of what establishes the rule of recognition. I mean, in Argentina, it's still a controversial question. This decision of the court has not precluded lower judges to take decisions that apparently we would say that are incompatible with what the court ruled in this case. The force of the decision of the Supreme Court in Argentina is not sufficient to preclude other judges to decide on the contrary. So I'm not so sure that any legal theorist in Argentina would agree with you that it is true after this decision that the content of the legal system is such that it is not a criminal offense in Argentina now to possess drugs for personal use. So I have my doubts that the content of the law is uniquely determined by what judges declare in particular cases.
So for the very last question, Eugenio, please.
Well, my question is almost identical to the one put by Guastini. I also regard that this problem of some lack of stability of the judges of the Supreme Court is no problem for the idea that norm propositions are true or false, because the truth of the norm propositions is of course relative to a certain set of legal norms or normative systems. Every decision of the Supreme Court changes this set, introduces a new norm. Well, a part of the psychological problem of the judges, it's only natural that the truth or falsehood of the proposition, of the normative proposition, would be different. And the fact that other judges might perhaps decide another way doesn't alter it, because the proposition is true regarding the set that includes a determinate sentence or decision of the court. Once the decision changed, the truth changes. It is no longer true. So I see no problem in this at all.
This is a point in which I have a different view from yours. I don't agree with you. And the same goes for your position concerning what judges do when they have to face a case where there is a legal gap. Your idea is that when the judge solves a case where there is a legal gap, the decision of the judge changes the law. No, that's not necessarily the case for me. What has to do the judge in that case is to take a decision where the law is undeterminate and the decision the judge takes involves the necessary supplementation of the system with another norm to complete his reasoning to justify a solution for that case. But that's not necessarily mean that the norm the judge has integrated in his reasoning to solve the case after the decision of the judge automatically passes to integrate the system. This is not necessarily the case, and it's not necessarily the case that when the Supreme Court solves a problematic case like the one I mentioned here, the law necessarily changes. Well, that depends on the the rule of recognition functions. In Argentina, the strength, I insist, of the decisions of the Supreme Court has not this effect. One thing is to say that lower judges, for economic reason, after the decision, they follow the decision because they know that if they decide on the contrary terms, it will be revoked by the court. But they have not the obligation to follow the decision of the High Court. So I think it is contingent that a decision, a judicial decision, produces a change in the law. But it's not a necessary feature of law, I think.
Okay, thank you, Jorge, and thank you everyone who participated.